My name is Vojchehoske, and welcome to the Real Estate Classroom YouTube channel. It's just a place where real estate professionals can get tools and tips to stay out of real estate jail. And real quick, if you would, click on that little red subscribe button and that notification bell. So the question for this video today is one that's very common in my continuing ed classes that actually sparks endless debate. Two questions we're going to discuss in this video. Number one, can a seller use the terms of a purchase contract to require the buyer to use a particular title insurance company? And the second one is, can the seller require the transaction be closed by the seller's preferred closing settlement agent or closing company? Two questions, two answers coming up. Now, it's very important before we move on answering these questions, we have to understand the mechanics of what we're talking about here, because all too often agents clump all these things together and they're really not. Two separate and distinct things we need to understand here. First of all, on the left-hand side of your screen, there's We, Cheatham and Howe Title and Escrow Company. There is typically a title and escrow company or sometimes an attorney that's going to be hired by the buyer and seller to close the transaction. That's what a title and escrow company does. So they're going to close the real estate side of the transaction, which is the seller side, and then oftentimes they close the buyer side, which includes things like mortgage documents and recording deeds and so forth. But a title and escrow company also has another function. They are typically the authorized broker for the title insurance company. Now, a title insurance company is not unlike a homeowner's insurance company or an automobile insurance company. They provide insurance policies and they indemnify their clients against a loss, and that's what we're doing when we're purchasing title insurance. We're indemnifying ourselves against a potential loss. All right, so the title insurance company typically on a residential sale offers three types of title insurance. They have the seller, the owner, and the lender title insurance policies. Now, there are fees associated with those, and typically the seller pays for their own, and then the buyer will purchase the owner and the lender policy should there be financing on this transaction. So the title and escrow company will then go out and purchase the title insurance from that title insurance company. Very important to understand this whole concept before we move on to answer question number 1 and 2. Question number 1, can a seller use the terms of a purchase contract to require buyer to use a particular title insurance company? All right, now we're talking about the title insurance company that's issuing the title insurance policies, and federal law is very clear on this. The Real Estate Settlement Procedures Act prohibits the seller from what we call conditioning the home sale upon the use of a specific title insurance company for title insurance. Now, there is an exception to this. Under Section 9 of RESPA, it is not considered what we call required use if the seller pays the buyer side of the title insurance. So if the seller is agreeing to buy the buyer's or the owner's title insurance policy and the lender's title insurance policy, then they can dictate who that title insurance company is going to be. But if they don't pay for it, they cannot dictate who the buyer must use. All right, question number 2. Can the seller require the transaction be closed by the seller's preferred closing or settlement agent? So the answer is yes. A seller is free to use the terms of a purchase contract to negotiate who the title and escrow company is going to be for closing the transaction. Note, this is not the title insurance company that's going to be used, but the title and escrow company. Now, a caveat here, and I want to make this clear to you top producing agents and you teams out there that have a financial interest in your own title and escrow company. It is very common for an agent to want to use their own title and escrow company. If you're going to recommend to your client to use your specific title and escrow company that you have a financial interest in, please, 1, have the conversation with your broker to make sure it's allowed in your state. And number 2 is make sure you have what's called a controlled business arrangement disclosure signed by all parties. It's just a disclosure that says, hey, buyer and seller, you understand that I have a financial interest in this title and escrow company. Very important that you do that. All right, key references. Because this is the topic of endless debate during continuing ed classes, I always wanted to make sure that I provide key references here. So on your screen, I provided references to 2 really good articles that discusses the very things that we discussed in this video. So I encourage you to check them out. Bottom line is, if the seller pays for the owner and the lender's title insurance policies, then the seller can dictate who the title insurance company is going to be. However, Section 9 of RESPA does not prohibit sellers from using the terms of the purchase contract to negotiate who the title and escrow company is going to be to close the deal. And then last but not least, and maybe most importantly, is please make sure that agents, please make sure that you use specific language in the purchase contract to make it clear that the seller is paying for specific title insurance and closing fees. I hope this video has been helpful. If not, at least sparked a little bit of debate within your real estate company. Make sure you have this discussion with your designated broker or your attorney before implementing anything that I've said here. Just a little risk management thing. Real quick, if you would, leave those comments, ask those questions, subscribe, hit the notification bell. Till next week, get out there and sell something.